So I've been working on an apple, so it might be different. So there's a top of my map. So most of Washington is cut off, which is including Seattle. I mean, if it's possible, if not, I'll just go with it. Yeah, things happen.
So welcome to the West Virginia Law Review's Home Rule Symposium. And this is our first panel on home rule and gun regulation, assessing gun sanctuaries that conflict with state law by concentrating on gun violence in Seattle and Pittsburgh. So my name is Rhee, and I'm a professor here at WVU Law. I also teach a seminar on firearms law and policy. And I have the privilege today to be joined by our two wonderful panelists, going from your right to your left. Sheila Simon is an assistant professor at the Southern Illinois University School of Law. Professor Simon rejoined the SIU law faculty after serving as lieutenant governor of Illinois from 2011 to 2015. As lieutenant governor, she worked on many issues, including education policy and secured funding for rape crisis centers. Professor Simon was the SIU Law Domestic Violence Clinic's first staff attorney, an assistant state's attorney, a staff attorney at Land of Lincoln Legal Assistance, and a private practitioner. She also served on the Carbondale City Council from 2003 to 2007. Matthew Davis is a visiting lecturer in law at the Birmingham City University School of Law in the United Kingdom, where he teaches constitutional, administrative, and criminal law. He is also a PhD candidate with the Birmingham City University American Legal Studies Center. His doctoral research focuses on the role that pressure groups like the National Rifle Association and the American Legislative Exchange Council play in the US to preempt local governments from regulating firearms. Okay, so Professor Simon, want to get us started, please?
All right. Can you folks hear me if I talk from here without a microphone? Any people in the back that can't hear me? Okay, good. I'm going for it. Tell me if I need to talk louder. I'm all wiggly and it's much better. Yes. So, one thing that you can take home from the conference, and I have to share with you friends, the highway map of the state of Illinois. There we go. It's really not, believe me. So while you guys get oriented with your maps, first, many thanks to all the students who have helped put this together because this has been really fun for me. And thanks Cam and Isabella for driving us from the airport last night. That was hard duty. I appreciate that. Thanks to Jenny Gross, who told me about the conference, one of my colleagues at SIU. And thanks to Professor Diller for queuing this up really nicely with your talk. I very much appreciate it. So if you want to get out your map, find Carbondale. It's at the bottom. So why does maps like this? I don't know. I got this yesterday at the Illinois Secretary of State driving against the facility. It's a large print map. It makes me worried about why they're doing a road map for people who have limited vision. Okay, I'm compliant now. So if you find Carbondale, it's in the bottom of the state. So kind of, if you find the confluence of the Mississippi and the Ohio, you're in the right department. It's not a big place, but that's Carbondale. And then if you want to, see if you can find your way up to Chicago. Because if you live in Carbondale and you want to do anything in the state of Illinois, you're going to spend a lot of time going up to Chicago because that's even though the state capital is Springfield, the political headquarters of the state is Chicago. So I know from my 4 years as lieutenant governor, I know all the best bathrooms and gas stations in the state of Illinois. And one of the best is in Effingham, Illinois, at the intersection of Highway 57 and 70. So if you can find Effingham, you can see that there. It's an outstanding gas station. I have to recommend this. Exactly. If you need to know where you can change clothes in the bathroom, you can do it at Jack Flash in Effingham. So anyway, when I heard on the radio that Effingham County was declaring itself a gun sanctuary, I was really distraught. I'm like, okay, so that sounds like a crazy idea, and does it mean I will not be able to stop at my favorite gas station when I'm driving up to Chicago? And didn't think too much about it after that, and then got this call for papers, and I'm like, this is it. This is the conflict between state and local government. This is what's going on here, so it's a great excuse to learn more about what's going on. So let me give you, what I'll do is I'll talk a little bit about the historical background of how we got to that Second Amendment sanctuary, what the whole sanctuary movement has meant over time in different ways, and federal, state, local regulations of gun, and then just a kind of a wrap up on what does it all mean about democracy. So, so the history, Parkland school shooting, lots of calls for gun control, 5 measures proposed in the state assembly almost right away, and local governments around the state do what local governments do, and I've been on the city council voting for, here's our resolution to encourage our representatives to vote for or against something. So Iroquois County, closer up to Chicago, says we're doing a resolution against these 5 new gun control measures. Effingham County looks at it and says, yep, we want to do that too, only we want to put a little bit more punch into it. Let's take advantage of this sanctuary city language that's being used in the immigration context, and let's call ourselves a sanctuary county for Second Amendment rights. So Effingham County did that, and the resolution says we oppose those 5 new bills, and by the way, if you pass any of them, we're going to be a Second Amendment sanctuary, and we're not going to enforce any of that. So that's where it started at this. Didn't start at the gas station, but you know the place now. Started there and then really took off. If you were going to avoid stopping at a gas station in any county that had a Second Amendment sanctuary in Illinois now, you'd probably have to drive from Carbondale up to just outside Chicago. We have 102 counties and over 60 of them have a sanctuary minute. And it's not just Illinois, it's all over. Professor Diller talked about blue cities in red states. Where this gun sanctuary amendment comes up is red counties in blue states, which is exactly what's going on in Effingham and those other places in Illinois. We've got a predominantly rural county in a state that, because of the overwhelming population of Chicago, is a liberal and democratic state. So that's the history. It just kind of caught on. People said, oh, that's a good idea, and it hasn't stopped. And the discussion of Virginia and Kentucky both moves towards more Democrats in either the governor's mansion in Kentucky, the legislature in Virginia, and all of a sudden local governments that are more conservative are looking at this and saying, do we want to be a sanctuary county or sanctuary city? So the first thing I did is I want to know more about what sanctuary is, and I looked up, and the really cool history of sanctuary, which I identified as a Christianity kind of concept, dates way back before that. It's associated with religious locations and fleeing to the religious temple, place of religious observation to avoid persecution. And it was totally cool. All the state people said, yep, we can do that. It's kind of a relief valve. And the church people said, yeah, okay, we can do that. Even got the okay from a whole series of popes who said, yep, this makes sense. Come to our church, live out your life in the church. You can be safe. Give up your worldly belongings. Cha-ching, score 1 for the church. And you can avoid the prosecution, up to and including the death penalty, by staying in the church. And for some reason, the states accepted this, you know. Gradually over time, that acceptance fell away. Pope turns it down. States are like, no, you've got to serve your sentence. You get convicted. But still, there's not a sense that we're going to go into the church and get people. So the next phase in development in terms of our perspective on immigration and sanctuary was in the 1980s, when people were being told they had to leave and often be separated from their families. And at this point, churches again offered a place for these folks to stay. So it's again a physical location. And this time, the price wasn't so much give up your worldly belongings as it was, could you help us educate the rest of the community about your situation? Can we be a part of changing what we see as an unjust law? Sure, let's do that. So it became a more political thing. And then the most recent set of immigration sanctuary, city ordinances, declarations, takes it into one further twist, which is not so much that we're actually providing shelter or providing a place for people to stay, but we're making a policy statement. We're saying we're not going to cooperate with that. And sometimes cities have room to say that. They have some law enforcement that can choose to cooperate with the federal folks or not. But some of the immigration sanctuary declarations are really kind of out there. So my daughter, my younger daughter, lived and worked in Chicago for a while, and she worked at a restaurant, and she told me one day, she said, "Mommy, do you know that our restaurant is the first sanctuary restaurant in Chicago?" And I'm like, well, good for you, honey, but that's not a thing. And obviously the restaurant is not sheltering people for years on end in the restaurant. They just keep you for a while and serve really good fried chicken. But they want to make a declaration. They want to make a point. They want to say, we recognize that these laws are unjust, and we're making a statement about it. So this is the context when Effingham County looks at the laws and says, yeah, we can use that kind of idea. We can make a statement. We can make a statement about our value for guns. So they did. So it took hold. So that's kind of the sanctuary thing. So that gets us to who regulates all this, which is really interesting, and I'm very much interested in what Matt has to say about pressures on localities, states, and who's exerting the pressure. So we have kind of a tension between federal and state government, right? There are some areas where federal can regulate, some areas where states can regulate, but not so much of a tension between state and local, because the states are big dudes in the fight, right? The states can say, if we want to take over and regulate this part, if we want to have our laws in this part, then you, the local government, are just going to have to back off. And that's exactly where these Second Amendment sanctuaries fall in, right? People are saying in these local jurisdictions, if you pass another law, if you limit our rights, we are not going to have anything to do with it. We're going to back off. We're not going to enforce that. And that's, of course, when the state law is going to preempt the local. So legally, the impact is just not much. There are different ways to challenge something that a local set of folks might see as unconstitutional, but saying we're not going to participate in your state law is not one of the options as far as I see it. So that got me far enough to know, okay, I can still go to the gas station in Effingham. But I wanted to think about it a little bit more and figure out whether there is some value in this. And I think there is. And I think it's the value of allowing a distinct policy minority in an area to be able to say something, to be able to have kind of a beefy comment. It's not just the letter to the state House and Senate member from the area, but a public statement about how we feel about rights that we think we have. And I think it exposes maybe a flaw in our democratic system, that we don't, when we're in the majority, listen often enough and closely enough to folks who have a minority point of view. So this theory of having local folks express more in terms of what they want to do, how they want the state law to be, has been coined as federalism all the way down by a professor, which makes a lot of sense to me. And she says any governmentally associated body ought to be able to have the ability to speak out about issues where even they don't have any control. Can the library board make a statement about immigration? Can the library board make a statement about gun rights or poverty or you name it? The idea of federalism all the way down says, yes, they ought to be able to do that. And we know it will have no legal impact because everyone knows they have no control, but it will make us a better informed governing body. Because when you look at that map, so I'm a Democrat, part of the majority in the state of Illinois, but I'm from the area where people have a minority point of view on using guns and possessing guns. And there's a whole lot of tension. And this year in some counties when we're gonna be voting in the primary, some counties are gonna vote for an idea that comes up on a fairly regular basis. Should we divide up the state of Illinois and make it Chicago and the rest of us, right? But think about that. So Illinois is not unique. There are all sorts of states that have a majority point of view and have a large urban center that controls a lot of the political power, and that can, when they want to, ignore the rest of the gang. And not that I think the majority ought to change its mind, but I think the majority ought to do a better job on listening to those who have that other point of view. And this Second Amendment sanctuary, I think, is a decent handle on having that point of view, having that voice in the process, and having your voice have just a little bit more elevated value. So that's my thing, and I will be able to toss it over to Matt, or should we have questions now? What's the plan?
Maybe we'll take one or two questions before we go on to Matt. Anyone have questions on Professor Simon's presentation in particular? Okay, I was going to say, otherwise, if you could hold your questions until the end, we'll have a question and answer period then. So.
How does that little bit of value that you talk about manifest itself, other than just making the statement?
In terms of the small group saying, hey, we don't like what the big group is doing, I think the value is to know that you've been heard, right? What do the malpractice insurers tell us about what's the best way to avoid malpractice? Is to always return your client's phone calls and to know that they have had their day in court, because people don't always, they know that they're not always going to be able to win, but if they feel they've been heard, if they feel they've had their day in court, even when they lose, it's a little bit more acceptable that way. So I think there's something to knowing that you were indeed heard, even if you don't wind up winning. They sure did. Like all the other counties, the 60-plus counties that have enacted this ordinance, and their representatives are overwhelmingly Republican. So they have a voice in Springfield, and their voice too is in the minority there. Yeah.
To what extent is this merely expressive, and how much is it actual civil disobedience? If the elected sheriffs are not going to enforce the law and the elected prosecutor is not going to bring charges, that seems a little more than just expressing opposition.
Yeah, so that's a very good question, because I think there is some misunderstanding on the part of some folks who are like, great, we're in a county that's not going to do that kind of liberal gun law. And I think everyone involved in the enforcement understands that that's not accurate. In fact, the state's attorney in Effingham County, who first proposed this language that was enacted, told everyone there, it's going to be, this is not going to have the legal impact that it looks like. So I think most folks who are informed know that it's not going to do that. There is probably some danger that if there's a general feeling that we can do more, that maybe things will get a little bit carried away. There's also a really interesting point, and maybe I'll save. I've got a question for Matt when he's done. All right. Anything else?
Great, thank you.
Try 365.
Oh, don't worry about it. So first, can you hear? So first, I appreciate the invite. It's the first time I actually get to present this to an American audience. So as you heard from my introduction, I teach in England, but as you can tell from my accent, yeah, unfortunately I don't have the English accent. But it is also great to be on YouTube too. I have a 7-year-old, and like the fact that I got to go to a conference doesn't matter. The fact that Dad's going to be on YouTube will score me points for about 30 seconds, so I'll try to enjoy them. So yeah, today I'm looking at case studies of Seattle and Pittsburgh and contemporary local firearms regulations in the face of the attack on American cities. And I frame this both to look at the paper for this conference as well as my overall PhD, which looks at pressure groups and how they impact the ability of local governments to regulate firearms, or to the extent they can regulate firearms. When I use the phrasing attack on American cities, obviously I'm stealing from Richard Schrager's research. The paper is Attack on American Cities. Somewhat a little bit pointed for some people, but I think, or provocative, but I think it kind of makes the point. And the recent times interstate preemption has been characterized as an attack on American cities. By that, I don't mean that they're going out and trying to completely erode what the cities do, but when cities pick up policy issues, they generally are trying to regulate an issue they don't see the state responding to, or they don't see the federal government responding to. And in a lot of cases, especially with more recent firearms preemption, it's not preemption in that dictionary sense, whereas there's a missing element that doing something first doesn't happen. It's usually a reaction to it. Within the research aim is actually to look at the strategic litigation efforts of pressure groups. My overarching PhD looks at ALEC and the NRA, but this one is a little bit more broad. But firearms is significantly different. Whereas I believe fracking has 16 states that have preemption statutes. Whoever has been involved with preemption of firearms has been extremely successful. And unfortunately, we've had a little technical error, so it's cut off actually the area where Seattle is. So I don't miss the irony in that. But I can guarantee that the map is accurate. I know Gifford Center and Everyday Town for Gun Violence has similar things. We just went through and pulled every single preemption statute from the legislative website for each state that has them. So when we're looking at this, we're looking at cities are still trying to regulate firearms. States are still acting. How do we try to understand why? How do we try to understand what these new issues are being tackled? We thought, well, let's look at litigation. What are they fighting over? What is the area of conflict? And with that, I chose Seattle and Pittsburgh because, of course, Pittsburgh dealt with the recent synagogue shooting, and they clearly said that in their ordinance, that they were trying to respond to this. But what drew me to Seattle and Pittsburgh as well is that they weren't just looking at mass shootings, which catch media attention. You see it on the news, but we see a lot of issues when it comes to gun violence that has to do with mental health issues. Someone having access to firearms that perhaps, given their mental state, shouldn't have it, or you could argue they shouldn't. Both cities actually saw this as a public health and a public safety issue. While not directly arguing policing powers, you can see that old-style policing power that you think about of protecting your city, or as the cities of Philadelphia and Pittsburgh argued in Commonwealth versus or Ortiz versus Commonwealth, is that this is the reason for our existence, to protect our people from harm. And also, when you look at some of the research that these cities attached, they didn't just put out an ordinance. If you go on their respective legislators, they actually put out research they were looking at. They were reflecting on the CDC data on gun violence, that over 38,000 Americans on average a year die of related to gun violence. And as we see from the CDC methodology, that might be underreported as well. what they also did is looked at potential factors or potential increased risks as the federal assault weapons ban was allowed to sunset. How is that impacted? And they tried to respond to this. And obviously the ordinances are far more complex, but for timing, I picked out 3. And I looked at the safe storage of firearms, which both cities tried to tackle, the extreme risk protection orders, which Pittsburgh tried to tackle. Seattle doesn't have to because Washington already has it on the state statute books. Reporting lost or stolen firearms, and magazine capacity. And I intentionally phrase this as magazine capacity because part of the argument is how we look at this when it comes to both the plaintiffs against the city of Pittsburgh and the city of Pittsburgh itself. The city of Pittsburgh refers to it as high capacity magazines, whereas the plaintiffs in Anderson refer to it as standard capacity magazines, right? So, is it, yeah, oh, is it not? Okay. Oh, it does have the graphics. Yeah. Yeah. At least this part worked, so. So before we go into it, we want to look at the state-local dynamic within each state. So with Pennsylvania, in Pennsylvania, Dillon's rule has been applied, and it was applied relatively early, even before Hunter versus Pittsburgh. So this is not a new phenomenon. With Washington, it was a little bit later, but we also see some remnants of it that Professor Hugh Spitzer from the University of Seattle, I believe it is, has actually argued that this is not what the legislative intent is. It's kind of this, judges not giving up this old view on the importance of Dillon's rule, and of course the fact that some special districts in Washington still, Dillon's rule still applies. So what he's effectively argued that there is some spillover effect with Dillon's rule when it comes to judicial review, when it necessarily shouldn't be. With home rule, it was relatively recent or relatively new, early in Washington, 1889, and it's in the state constitution. Whereas Pennsylvania, the state legislature literally had days left to enact the statute before they finally did. So there's significant contrast in early development of the Constitution of Pennsylvania. It really did not have an idea of any concept of city autonomy, or at least not to the extent that Washington did. Is that working? Okay. Now, both states have preemption. And effectively, when we're looking at these policy issues that I've raised with the city ordinances, is I'm looking at sub-policy issues, or trying to find a way to question whether the state has fully occupied the field, or to what extent they have. And then if that extent is not complete or absolute, what areas can they actually regulate on? With Washington, it says it fully occupies the field, and when it comes to registration, licensing, possession, purchase, sale, acquisition, transfer, discharge, and transportation of firearms. But it's not working. Okay. With Pennsylvania, similar in it prohibits any municipality in any manner to regulate the lawful ownership, possession, or transfer of firearms. But the other thing that the state of Pennsylvania did was to add the second clause down there. That's actually part of the home rule law. When it came into force, they said, you have home rule, but just in case you think you might be able to regulate firearms, think again. And this has been part of the issue when it comes to cities trying to argue some level of authority when it comes to regulating firearms. And if you look at some of the judicial history in the state of Pennsylvania, it's actually Pittsburgh and Philadelphia repeatedly that are the respondents to some of these cases. They've tried this over and over and over. And it's the same thing with Washington too. If you go through a lot of the jurisprudence when it comes to city authority for regulating firearms, it's plaintiff against Seattle, more times than not. So with the Seattle suit, and both of these are actually pending on appeal. With the Seattle suit, the first one was Alim versus Seattle, which was backed by the NRA. They were originally party to the lawsuit. And what they did was they were challenging first the safe storage ordinance that requires you to lock up your firearms, or at least put a trigger lock on it, depending on the type of firearm. If it's a handgun, you put a trigger lock. Or in other ways, just make it inaccessible to people who are unauthorized users. It's not meant to make it impossible for the lawful owner to use that firearms. The idea is to protect, your child, for example, from being able to pick up your firearm. And also what they wanted to do is for you to report lost or stolen firearms. Nothing more than that, nothing to truly infringe. And Seattle, though, I would say, had a little bit cleverer of an argument than when it came to Pittsburgh. Seattle actually challenged the NRA standing. They effectively said that the NRA did not suffer any harm because they don't have a policy that says that they're against the safe storage of firearms. And of course, challenged rightness, and in fairness, the NRA probably jumped the gun. The ordinance wasn't actually in force, and they filed. And so this was kicked out at first instance, but it is on appeal. And we've also been watching Bass versus Edmonds, just because Bass is actually a city ordinance, or city as opposed to Seattle, which is a first-class home rule city. So we're trying to see whether having a home rule charter matters. And to some extent, we've seen in other fields, other areas of local authority, it does matter. But does it matter specifically to firearms? With Pittsburgh, we actually have picked out the three main cases that two of them are being appealed. The original case actually was looking at whether these ordinance related to safe storage of firearms and extreme risk protection orders actually violated an old agreement between the city of Seattle, or sorry, the city of Pittsburgh and a old applicant. So it was effectively a contempt of court for not following a court order. But they challenged both city ordinances. With Anderson specifically challenged magazine capacity. And this was an interesting case because Anderson argued that it's not high capacity magazines when you get above 10 rounds. And they actually went through the scenario of saying that, well, if you only allow 10 rounds, and this is actually in the court documents, that you may not be able to repel multiple assailants. Like the idea that you would need more than 10 rounds, and this is just a standard course of life, that if you can't have high capacity magazines, you might not be able to protect yourself if someone attacks you. This is an actual argument. Ultimately, the case hinged on whether the state had fully preempted the field, and the judge in all three cases, same person, ruled that it had. And in firearms owners against crime, if the name stands out, it's because they're a regular litigant. If you see Harrisburg, the city of Harrisburg is actually facing a case against them right now that is already at the Commonwealth Court. Unfortunately, with a lot of online court systems, the Pennsylvania state court's been down, so we don't know where they are with the Commonwealth as of last week. So, like I said, the interpretation of the state preemption clause is having reserved the entire field related by Judge James, who was the judge in all three cases against Pittsburgh, is based on really strong precedent. I raised earlier Ortiz versus Commonwealth, and effectively both the city of Pittsburgh and the city of Philadelphia raised this argument that this is what we exist for, the idea that we represent our people, that we have to keep them free from harm, or at least to the extent possible. And the court directly said that this argument was frivolous. Not reject, not that you don't have the scope, frivolous. And honestly, as a result of that, I think that the precedent suggests that Pittsburgh's not going to be successful. And I think, but with Washington, we have something a little bit different. We have this idea of a distinction between the legal result. So in Cherry, they actually looked at the legislative history in Washington. They found that the actual intent for the preemption law wasn't to completely preempt the field on every count. It was to actually create uniformity in criminal law in Washington. And if you look at how the ordinance in Seattle is drafted, it looks like they're trying to do that, and they're learning because they have missed out. They've tried it before, and they were challenged in Chan when they tried to regulate the use of firearms in public parks. And ultimately, the actual penalty for that was seen to be a criminal penalty. But in this case, in these two ordinances related to safe storage and related to reporting lost and stolen firearms, it's clear, at least in my opinion, it's clear that it's just a civil law result. And so I think on that case, I think that Seattle will be probably successful, but what I'm quite interested too is seeing how both Elim and Bass play out, because it'll give us an understanding of whether home rule is even relevant when it comes to the regulation of firearms, because you have a code city in Bass and a first-class home rule city in Seattle. It looks like on the merits, because they're both dealing with safe storage ordinance, that they might be combined when they go to the state Supreme Court. It'd be interesting to see whether a home rule city in Washington does have the authority that a home rule city in Pennsylvania does not have when it comes to regulating firearms. So, I mean, very clearly, what we've found to date is that there is a differing level of municipal authority for cities to regulate generally when it comes to Washington and Pennsylvania. And we do see that these strategic litigation efforts of these pressure groups, in this case, generally the NRA or NRA affiliates, is part of this broader attack on American cities. But it also is following that same trend of not really preempting in the dictionary sense, but responding to policy innovation. And what we're seeing is, in a lot of cases, it's when states are doing nothing, the federal government is doing nothing as well. So they're not necessarily trying to jump into a field that the state has preempted and then turned around and passed legislation to deal with a certain issue. Effectively, what the strategic litigation efforts are doing is the same thing that these preemption legislation has been doing, is maintaining the status quo. And when I say maintaining the status quo, I'm referring to the firearms violence we see now. Over 38,000 Americans at least dying every year with firearms-related violence. But you also have things that, if you look at, in 2016, the High Commissioner for Human Rights for the UN actually raised these issues about how even when it comes to firearms violence, it actually impacts other people's rights. It impacts your obviously the potential for right to life, but your willingness to freely express yourself. For example, if someone can carry a firearm to a political rally, or as we've seen in past elections, when a candidate was speaking in Arizona, it was okay for someone to openly carry a firearm. But the other thing that was raised too is that when you allow for free access to firearms, such as especially when it comes to extreme risk protection orders, you expose people who have suffered from domestic violence, especially in a repeated issue, is you make that situation more extreme to them. You actually expose them to potentially being harmed a lot more. And that the thing is that when we see, for example, in the state of Pennsylvania, is there is no extreme risk protection orders, despite the fact that now we see the governor is actually, for some of the legislation, has actually been supportive of Pittsburgh. They're not doing that. So the idea that you can have access to these firearms is something that is just being left. There's silence on the legislative end. And I think when we see, and the other interesting thing I've seen with looking at the strategic litigation is looking at some of these issues going forward, especially this criminal-civil distinction, is there's actually a bill before the House, I believe it is, in Utah right now, that is actually trying to close this loop, where they specifically, completely and entirely preempt the entire field, including express language for this civil criminal penalty, and also looking at this issue of legislative immunity. So we're not the only ones seeing this. It's these pressure groups are actually looking at how the cities respond to these litigation strategies. And at the same token, when we see other cities, when it comes to these pressure groups, like the city of Carson in California, they were ready to pass local firearms regulation, and then the NRA got people to show up. They threatened suit, did the same thing with Los Angeles, and both cities backed away. So what we're seeing with this as well is not only the enforcement of preemption, but these cities are being made an example of. So if you're a smaller city that might want to do this, the fear of litigation makes you just cringe at the idea of doing it. So something you would rather, as a city council member, that you might want to get involved with, you feel restrained from doing so. And with that, thank you.
So before we open it up to everybody, Sheila, did you have a question for Matt?
There we go. In firearm advocacy groups choosing to advocate for their rights at a level of larger government, at national or state levels, and having been involved in government both at local and state levels, there's a real difference in responsiveness and how you can change things. It's an interesting strategy choice to me for a right that is founded on the idea that we ought to be able to use the firearms to change our government when we need to. So is it a big strategy picture, or is it just we see this opportunity here, so we're going to take it?
I think I can answer that in part, just to the extent I see it. I do think it's part of I mean, you see the opportunity, you know, where when it comes to cities, for example, when they try to organize for something like this, it's a little bit harder. They don't have the political power, especially in states where you have cities that, or politicians cannot run on a party platform. They must be apolitical. So how does, you know, in California, for example, if we had the opposite version where we had a more Republican-controlled legislature and they were wanting to preempt a lot more stringent, like Pennsylvania, smaller cities couldn't do much because most of the city representatives or city politicians are not allowed to affiliate themselves with a party. So I mean, part of it is that they see first they've been successful. Like that when it comes to firearms, that's the one thing that I keep reiterating when I present my work is that when it comes to firearms, they're just more successful. So it's taking advantage of the success you already had, but also recognizing that cities are an equitable issue. Like I think Professor Diller was raising some research done on looking at, you know, the less that cities in California spend on lobbying, the less they get back in terms of funding too. So when you see this inequitable bargaining power, inequitable just power generally for cities, they're just taking advantage of what's there.
Yeah. Okay. Thank you.
Thank you. So we have plenty of time for a question and answer. So for anybody.
So, Matthew, it seems to me, thanks. I don't know if you can, well, we probably all remembered. Your first slide seemed to me to be the most important one because that was the slide that showed, I think, the states where you have statutes preempting local firearm regulation. And that was about, what, 45 states or?
Yeah, 43 and then 2 that are kind of, you know, hybrid where they do a little bit, like California, for example.
So the litigation of groups like the NRA or these other groups you mentioned, I mean, they're only good strategies because you have those laws in the first place, which I think go back to the 1980s, maybe the 1990s. Yeah, they haven't been around forever, but they've been around, you know, 30, 40 years. So I guess I'm surprised, or I want to know more about, like, what is Seattle doing to overturn those laws in the Washington State Legislature? Is there talk about that? My guess is in Pennsylvania, it's a little less likely, but it would seem like in Washington, why is that not in, to use a bad pun here, the crosshairs of the state legislature, you know, to get rid of those laws?
Well, there actually is HB 1374 that's being debated right now in Washington that would actually go further than, I know Oregon has tried to give a little bit more authority, but this would actually pretty much remove that preemption statute in Washington. It was introduced last year and just went to committee and went nowhere. First reading and that's it. And so far, that's where we are in Washington. But it does show that there is a little bit more. But the other thing is with Seattle is that, you know, the law just gives them a little bit more authority. If you look at some of the other places where they've been successful, they've actually been able to tax firearms, and as long as, under Washington state law, as long as you can show a public benefit, you can do that. So in a way, you're regulating firearms by using your taxing authority, where, if you look at, gosh, I can't remember, there's a long 2001 survey of all, home rule in the United States. If you see some of the other states that have no taxing authority and very little financial authority, that's just not possible.
Thank you. Any other questions for our panelists? And again, this is being simulcast, so if you could wait for the microphone, we appreciate that.
Yes. For me, I see a strong parallel between the current debate about firearms as well as the debate about marijuana legalization. In a lot of those cases, the states and cities have taken steps, even such as the Morgantown City Council right now has voted to decriminalize, but it's created a bunch of other issues there. My question really is, have referendums, local or state referendums, been used as a tool to debate some of these topics around firearms? And if they have not, what have been some of the reasons that they haven't?
Well, that's a good question. I know in Illinois we have very limited ability to have referenda, so it's just not a tool that we're using. It's an interesting parallel with the marijuana situation. I think that's more of a conflict between, well, I say this from a state that just legalized it, right? So we're just branching into this, but it's more of the challenge is the difference between federal regulation and state regulation. And here we're interested in where the state and the local are butting heads.
Yeah, I mean, I definitely see the difference between, with firearms, the state's not necessarily trying to regulate that would be contrary to the Second Amendment. No one's arguing that. Whereas it's been completely legalized in California. It's still federally, there are potential criminal liability for, being caught with marijuana in California, even though the state has legalized it. There is a distinction that way. I'd also make a distinction in terms of, relying on both the argument that, Seattle and Pittsburgh have actually made, that of public safety and public health, whereas, people can argue about the merits of marijuana, for example, but 38,000 people aren't dying each year of, the use of marijuana. So.
I'm wondering whether if you uphold one city's ability to put a magazine capacity restriction on guns, does that necessarily allow the city next door to become a gun sanctuary?
Well, I think that's really one of the most interesting questions here is at what level do we choose to regulate? And I think if you decided to regulate this on a more local basis, you could in fact have cities where one city heavily restricts guns and a city a few miles down the road says no open carry or whatever we want to do. So I think that's the possibility. And in fact, we were talking earlier about this is how these statewide preemption ordinance got started, because a city in Illinois said we're going to outlaw all handguns. And then there was this reaction to that. So yeah, I think it's a choice that we can make. Do we want to have more state control and uniformity? And there's great advantages to that, even for gun advocates, gun owners, to be able to know that as they travel through particular places, they're going to know what the regulations are. But there's also a lot of room, I think, for recognizing different characters of different areas and saying that in one place we might choose to operate our gun laws differently than another place, and both laws be anchored towards safety.
Yeah, I would also point out some of the research we were talking about from a professor from Duke, Joseph Blocher, who's actually argued that you should have this idea of firearms localism, so allowing for more urban areas to actually be able to have stricter gun controls and more rural areas to have less restrictive. And part of the argument that he actually has is that when you're out in rural areas, we can go hunting and do stuff. You're doing what's you're more likely to do what is, permissible under the Second Amendment, for example. But I would also say when we're looking at these issues between whether this city can have stricter firearms regulations and the next city might become a sanctuary, is that even when they're regulating, they still have to comply with the Second Amendment. They can't overstep, constitutional protections. And we do still see cities facing that. For example, Chicago with Ezell, the city and county of San Francisco in Jackson, their safe storage ordinance was challenged as well. So we do want to look at that and look at how you can respond differently, but we also need to remember that even within this framework, we're looking at this state-local dynamic, we still have a Second Amendment that we still have to adhere to.
That's a good point.
Hello. I had a question for Mrs. Simon. You mentioned multiple times that the minority often want to just let out their point of view. But I was wondering how much of it also includes the tradition, the needs between the big cities and the rural areas. Like, in your experience, how can we help this tension by a regulatority's point of view? And also, I was wondering how much of the economics could be affected in these occasions, like if rural areas have hunting season, if rural areas have gun shops, rather than big cities that it's not really much needed there. So I was wondering about the economic side of it.
Yeah. So the question about culture is really an important one, because in fact, the Blocker article refers to that we have different cultures about guns, and in some places, growing up hunting is a tradition that's passed on from grandparents to grandchildren, and we have very differing points of view. One of the reasons I just realized now, thank you for that, for passing out the maps, is that the map on where we have these gun sanctuary ordinances is very similar to a lot of other maps in the state of Illinois. There's a rural advocacy institute at Western Illinois University, and they have maps on things like access to dental care, spending per pupil in the state of Illinois, poverty rates, and the maps are so similar. We've got rural areas, big rural areas that have less of many things. We have urban areas that have more of many things, more of opportunity. And some of it is choices that we make, but I think some of it is that we in rural areas are failing as advocates for ourselves. So I think there's some cultural divides that we would do well as residents of rural areas, and I say this as a rural person, or at least that's how I identify, can we use that language, that we need to be better advocates for ourselves and make sure that people who don't share those cultural values at least understand our cultural values in the same way that we need to make sure that we understand theirs. I got together a group of freshman legislators when I was lieutenant governor, and we had to pass a concealed carry law in Illinois. We were the last state to have a concealed carry law. And what I arranged was an urban and rural, Democratic and Republican study group. We went to the state-sponsored gun range in Southern Illinois. We heard from gun owners who wanted to be able to travel through various states and know what the restrictions would be. And we met in a church basement in Chicago with surviving family members of victims of gun violence. And there was a lot of waking up going on from both sides, from people who came from one perspective and then had the opportunity to see the other and to see the human side of the other. So I think we have some more ability to do that. Your second part of your question, though, on certainly there are places in rural America that where firearms are important to the economy. And where what you do with firearms is important to the economy. So yeah, that's a big deal. Yeah, thank you.
I think another wrinkle to this is not just culture, but need. So for example, I lived in Seattle one summer, and with the first week that I moved there, literally down the street there was a mass shooting in a coffee shop where we were going to go. And there's serious mental health, lack of access issues in Seattle. And so that combination with guns, it was just palpable that there needed to be more restrictions in a place like Seattle. Compare that to, say, my aunt who's in her 70s in Oregon, in rural Oregon, where they lost funding for law enforcement. There is no sheriff. She has to have guns to protect herself. No one will come. I mean, she can't even call 911 where she's at. And so it seems to me there's just a tremendous difference in need surrounding firearms in this country that perhaps a blunt instrument of preemption would disregard in a really dangerous way. And I don't know if you have looked into some of the rationales behind sanctuary or preemption. And I'm sure it's not just cultural, but it's addressing true public health issues.
Absolutely. I'll say that. Absolutely.
No, I mean, I agree as well. I think, honestly, I hadn't heard about that specific issue where you lose, but it makes sense that it is. But that's the thing about preemption as well, is that it is this one size fits all, that everything becomes, a statewide issue. Whereas, I mean, Seattle is a great thing. But I mean, when it comes to firearms generally, we also have to remember that there is, not just in America, this idea of different need from different places, the idea of attaching culture. Like even in the European Union, they recently had a case deciding where it was against the Czech Republic, where they were arguing that the European Union couldn't regulate firearms because this was part of their deep history, and firearms are a big thing in the Czech Republic. There's a famous firearms brand that's sold here. And Poland actually made a similar argument, intervening. So it's not just, I mean, we think about it as a uniquely American thing, but there are some ties of culture and different needs. For example, when you live in a rural area, regardless of whether you're in the United States, if you're in rural Wyoming or in New York City, or if you're in Prague or somewhere out in the sticks, these issues do tend to, I mean, it almost seems like it's kind of this natural human thing, especially in our modern states, is that we have this cultural tie to it, and we have very differing needs. But specifically with the U.S. too, I think part of the issue too is that something that some scholars have argued about, this idea of that the way we look at authority of cities is not keeping up with how we've shifted from an agrarian society to a more urban one as well. And I mean, you can say that for the urban cities, but perhaps we're also not thinking about these more rural areas as well. And part of that might be to this kind of adversarial nature we have to certain hot button issues where, for example, we assume that Republicans are the only ones that are promoting this pro-gun agenda, where if you look at some states where there are Democrats that have actually come out and supported stronger preemption as well. So
I think one of the things it gets back to is Professor Deller's point about redistricting, because I don't think we'll have effective representation unless we have redistricting that is less partisan. The redistricting that we have now drives the races to the primaries, and then the primaries drive the people to the extremes, and that leads to folks getting together in Springfield, in Washington, thinking I'm on the other team rather than I'm part of a democratic process. So maybe the next time we get together, I'll get to hear a great paper about how we've made great progress on redistricting. I'm hopeful. Yeah.
Any other questions?
Thank you for coming, talking about this. Something, Matthew, that you said during your talk about there being sort of a vacuum, a lack of guidance from Congress, or just any kind of federal legislation, and so you're having this fight between states and local governments. So I'm sort of thinking, could you pass a federal law that preempts state law's ability to preempt local governments, and just sort of have a federal law that says, you guys figure it out, whatever it is, we're not going to stop it? I mean, is that a solution? I mean, good luck trying to get that passed, but just wanted to hear your thoughts on that.
anything in this climate that would erode the Second Amendment in any way. No, probably. I do know that when it came to trying to encourage less preemption when it comes to firearms, specifically with safe storage, for example, last year, I can't remember what all of the members of the House, but I guess they generally refer to them together as the squad. They actually put forward a bill that obviously didn't go anywhere that would actually call for more authority for cities to do this stuff. But when it comes to actually, I mean, and of course it went nowhere. And the reason why I raised that, like both sides of the argument, I just don't see it going anywhere because, you know, it's not, and I wouldn't just say it's the National Rifle Association. I think that there's kind of this sense of identity that certain people have that are pro-gun rights, that they see the Second Amendment as something important. And sure, it certainly could be. But in terms of, you know, working against a big lobby in Washington to get something done, I mean, seems like a fool's errand, honestly.
Yeah, I think it's theoretically possible. There you go.
You just mentioned safe storage laws.
Mhm.
I'm not sure why that's even an issue in today's society. In 2008, it's my understanding that the Supreme Court held unconstitutional the trigger lock provision that DC had in effect under any standard of review. What do you think? Why do you think that's still an issue being litigated today?
Was it trigger lock? That it was basically banned. DC?
Yeah,
Heller?
I'm okay. I don't know enough about the trigger lock issue to comment.
Yeah, I mean, I don't remember Heller actually being absolute on that. I do know that Jackson was dealt with by the Ninth Circuit, and they obviously it was done on procedural grounds. They said that effectively Jackson didn't have enough of a strong case to challenge safe storage on Second Amendment grounds to even go to trial. I would assume that an inferior court would not directly overrule the Supreme Court. I know it's been challenged both in two other courts as well, courts of appeal as well, and honestly, probably the honest answer is just it's probably an unsettled legal issue. So that's probably where it is right now, where it's probably just unsettled. But
Professor Davis, you mentioned that you thought Seattle would have a better chance than Pittsburgh in its litigation because of Washington's mere attempt to create uniformity in the law rather than intent to preempt. I'm wondering if you could elaborate on the distinction between the two.
okay, so it wasn't just uniformity, it was uniformity in criminal law. So that was their intent, was purely criminal law. And I think that has a stronger argument compared to Pennsylvania, purely for the chance it's much clearer in jurisprudence as well that we've absolutely preempted the field. Even the strong police argument, the court actually did say that the argument was frivolous, the Supreme Court in Pennsylvania. So I'm just reacting on what the jurisprudence tells me at this point. So I think the fact that there is that scope, and the fact that in other issues we see, you know, from Hugh Spitzer and looking at some of these nonprofits that, you know, support municipal corporations in Washington, that have actually argued that more authority is dictated by the Home Rule Charter for at least certain cities in Washington. So that's where I see the difference, whereas in Pennsylvania, it doesn't seem, especially when it comes to firearms, that Home Rule matters at all.
Any other questions?
Yeah, this is for Professor Davis. This is a couple questions here I got for you. First of all, you cited 38,000 firearm deaths. Does that include both suicide and self-defense usage of a firearm, or is this just homicides?
It's a few years dated, so CDC doesn't really necessarily get all the funding to do these reports anymore, you know, lobbying efforts. But I do believe it accumulates all of them. But like I said, it is underreported because, you know, sometimes they just don't get reported. So the reason why I said it's actually a little over 38,000, it's just a rough ballpark of what the research suggests from the Center for Disease Control.
But that's total deaths from firearms. They don't distinguish it, right?
Right.
Okay. The second question is, what liability, if any, does a municipality have if they pass either a red flag law or restrictive rights on the Second Amendment, and as a result there's a death? For instance, if somebody can't get to their firearm because they have a storage law that says it has to be locked in a safe, and a burglar breaks in and kills that person, what liability does the municipality have in regards to that?
Honestly, yeah, I wouldn't answer the question directly. My background is not in municipal law, and I would assume they would depend on the state. Yeah, that's just not my area of law.
Will, you have any expertise to offer?
Yeah, I don't actually have an expertise in that. I think the political implications would be very, very strong, right? If that were to happen, then I think there would be there would be a lot of lobbying to try to to change those regulations, maybe.
I do have some experience with the Municipal Attorneys Association in West Virginia, and I will tell you we would be sued. The NRA is not shy about lawsuits. They have a lot of money. They do not discriminate upon small cities or large cities, and they spread the wealth, if you will. But it's almost like a damned if you do and damned if you don't. So, most likely we would be drawn into that as a municipality.
So you would be sued, but couldn't you claim sovereign immunity, or would the sovereign immunity be waived in that kind of situation?
We would probably use everything that we can in our toolbox. But as far as the action of the municipality enacting the ordinance, I'm sure we would have the types of discovery that would be that we would be pounded with discovery, such as where are your empirical research in regard to undertaking this ordinance, the comments at the public hearing, the backgrounds of the governing body as to their different orientation in regard to gun control, et cetera. It would probably, basically, it would tax very, very much the municipality. Of course, we have insurance defense, but then again, some of the provisions in the insurance defense may knock out all of the potential defenses. A lot of people now will form a deliberate intent claim, and that will override our insurance provisions and then potentially bankrupt a smaller municipality.
So would that influence advice that you would give to a municipality about considering some kind of regulation?
Oh, surely, anything like that. Number one, there are municipal experts that even to assist your local council to employ, and then to have a ton of research to back up why that ordinance is being enacted, so that you have a better factual basis other than, gee, this was a good idea that Tuesday evening.
Understood.
Thank you. That was a very provocative question. It was very thoughtful. Anyone else got any questions?
I wanted to chime in with one last question for Professor Davis. I wanted to go into a bit into your experience in the UK with their examples. We all know that Scotland's a little more rural. There's Wales, there's Northern Ireland, there's England. It's not just one big city in England. So I was curious if you could go into a little bit about their experiences in enacting their regulations, whether they attempted to balance any of these interests, or they just adopted uniform laws for everywhere, or really just to explain a little more about their experience in enacting their choices and how they came to those decisions.
Okay, yep. So the one thing I'd point out before we kind of do some distinction, it is a unitary system, literally, and Parliament has parliamentary sovereignty, so whatever Parliament says, legally you have to do. So there's a lot difference, and especially when it comes to political influence that people can have. But as far as I'm aware, what actually prompted a stricter gun control, it was always slightly more strict than we have here, was actually a shooting at a school in Scotland. And that was the response. Pretty similar to what you saw in Australia as well, where there was a mass shooting and then all of a sudden they had a buyback program. So, I mean, it is different, but, you know, there are some like cultural differences as well, but there are certain examples too that you can look at other countries that actually have a little bit more requirements when it comes to firearms that, you know, if you look at it, it may not actually restrict, especially people that would normally, any person would suggest would have a lawful right to exercise the right to bear arms. If you look for, I was Czech Republic, for example, you have to go through a health check, you have to go through a mental health check. In Germany, especially for younger firearms users, you need to be tied to a gun club. And there's also the potential, depending on your age, depending on your, they can actually ask for a mental health check for you to have control of firearms. But going back to England, it is somewhat restrictive, but I think sometimes when you see the media coverage of it, you can actually get licenses to carry. But the firearms dynamic is different, though. We actually, in the UK, not all police officers carry firearms. We have special firearms expert officers that have to go through special training for it. So it's an entirely different culture when it comes to guns as well. So, I mean, it's interesting to compare, but there's a lot of differences that kind of make it really hard to kind of draw too many examples from it to use in the US, I would say.
Any other questions? Okay, well, I have a few, so, or maybe two, okay, since we're all. Matthew, this might be beyond the scope of your research, but I'm curious to know if sort of more gun safety leaning organizations like Everytown for Gun Safety have ever tried to sort of use similar tactics like, you know, ALEC and the NRA on a local level.
Actually, yeah, you just reminded me of something I should have included in all 5 of the cases I covered are actually being supported by Everytown for Gun Violence. So yeah, the answer is definitely yes, they do that.
But do they do it mostly in a reactive way?
I mean, to the extent my research is looking at it, my research is just the way it's set up is generally more reactive, so that's what I'm looking at. But so I couldn't comment to whether they provide, you know, preemptive advice, but, you know, definitely from what I've seen, reactive.
And Sheila, this is just a basic question about sanctuaries that maybe you've already addressed, but like, if a local, say like county sheriff just said, hey, you passed this state ordinance on guns, it's legitimate, we're not saying it's, we don't think it's constitutional, but you have the power, you're our superior, we're just not gonna enforce it. You can come and you can send state troopers to come and enforce it, but in our county, we're not gonna enforce it. And then sort of related to that, is there sort of a disciplinary issue when you have sheriffs, you know, saying that they're gonna deputize people and not, you know, like how is that handled as a personnel issue, maybe even just?
Yeah, so who's the boss of the sheriff? The electorate in the counties where the sheriff is elected, which is certainly what we deal with. So I think the sheriff is going to have less discretion because the sheriff is going to have the sheriff's association who's going to say, here are the kinds of liability that you would have if you choose not to enforce these laws. The more interesting question where there is some discretion is with the prosecutor, who does have a great deal of discretion and could say, okay, so the sheriff's made the arrest, but I'm not charging the crime. And that could certainly happen and is well within the range of the local prosecutor to make that decision.
Thank you. Y'all have any, we have a little bit of time, any last remarks or comments you want to make?
Thanks for your attention and your questions.
All right, well, thank you. Let's give them a hand.
Thank you again so much to our panelists and to Professor Rhee for moderating. We are going to take a short 10-minute break. There are snacks in the hallway, so I hope you're hungry again. And we will reconvene at 2:45. Thank you. Yes, in here. The rest of the afternoon will be in this room.
Thanks so much.
Hey, thank you.
And that was a great stump speech. You got my vote.
Yeah.
I mean, hey.
Well, thank you. What a
I
deal.
felt like I was trying to play catch up after you being able to walk through the crowd like that. Oh, thank you. Thank you for the question. Oh, thank you very much.
What are you going to do when you're done?
Okay. Should I leave? Should I turn it off? You can turn them on. Okay, turn them on.
I am aware.
It might also be a poor interpretation too, because under California state law, 'cause that's where I grew up. I used to actually, so even though I argue the gun control, I actually have had a firearm. I had a firearms license, passed the test.
Yeah, that's actually a point of contention right now is that the Supreme Courts are sort of ignoring Second Amendment jurisprudence from the Supreme Court. And I don't think that your argument is valid because well, yeah, I'm just saying that I think that's nonsensical. Not you, but the court's applying it because that's exactly what they talk about in the argument. Like, even when you're not using it or using it, it is in use. It says that it's got to be at the res to be used in a weak social raise people with bad eyesight, to take critical, unlock and key the law, and stuff. So it always needs to be readily accessible. So in a under any basis, even rational. Yeah, well, I mean, like, enforcers have actually used that standard of use until that very good.
Yeah, I'm staying at the same hotel. My university is so if you're looking, yeah, oh yeah, that's good. Well, I woke up at like 4:45. Oh geez, yeah, wow. Because it's weird that guy. This is just that just it's fun though. It's kind of nice to actually hear my research and hear like because I'm just finished with the first year, so it's kind of like I don't get enough questions about taking it right. We have to actually communicate for our groups. You actually have to go before and so it's better to hear it now here where it doesn't count. You submitted your paper, you think you have that doctor truck, no, you care.
So I would ask just a second question. I was really curious. I don't know if you were asserting it or if you were just sort of parroting what other people asserted. You talked about the idea that Second Amendment rights are inherent in the firearm and infringe on another person's First Amendment rights. What was your sentiment?
So the argument, so this is actually from the previous so what he actually said is when you don't have any limitations on it, especially when it comes to the previous protection order, or people who have strong propensity to ask domestic violence, especially when you use it as a weapon. It's not Second Amendment itself, but I know for a fact that the other arguments, if you look at how the control guns and
so it was a UN official talking about the U.S. extreme risk protection.
Well, from Saudi Arabia, right? He's from Jordan. Yeah. So what it was the there's some irony here. They actually did a report on
okay. Yeah, because when I heard that at first blush, I was like, that's absurd. Because, I mean, assuming that argument's valid, that's grounds for disallowing people the fundamental Second Amendment rights in general. I mean, we already lost on the books to prevent maybe it's because he's talking about U.S. law, and that it is fundamentally U.S. law. Well, I would think that the Human Rights Organization would be the first one to champion fundamental rights. Yeah, they will. I was thinking about asking. Yeah. But the thing is, well, I think actually, to be fair though, I think it's great because I thought it was slightly disingenuous, if I may, to refer to the panelists. Well, I'm sorry, I don't know. That's what I was so my immediate thought was confused, but I was like, no, it's right, right. Even they get their power from the state government, so if you're indirectly suing them, maybe that's. But I mean, honestly, oh, hey, don't get me wrong. I'm sensitive as well. I've been at a funeral more than once. Unfortunately, had a young teenager and I was gun. Actually, proposed to state senator months ago, and it's actually the bill that provided a sales tax exemption for gun sales, and an exemption for providers. I mean, I'm all for it. That's not my thing. I was just mentioning that. And I think even in no bus to say storage, the word already rolled on. It's ironic. That's why I thought that's the question. You know, Supreme Court. That was for and that was one of the only issues in which it is settled law. It would seem, and it would seem. Right. And so, but I would say as time goes on, and certainly the composition of the court changing in recent years, I think that the delta dispute between states and municipalities is going to diminish as more and more things get taken off the table. Yeah, I mean, I'm sitting for and it wasn't like they were all like 60 or 70, it sounded like 35. I'm giving them teaching. After three. Well, hey, I'm equally blind as well, so I'm completely on the other side. So I think there's always going to be a vast chasm of disagreement, but I enjoyed the talk very much. Thank you. Thank you so much.
about a half an hour
Okay.
for Q&A. So
Okay.
hopefully we'll have a live audience.
Okay.
That would be my hope.
Great.
Okay.
I love it. I thought they were really nice. Like, I've got two gentlemen on the panel. They'll like them.
Hey, I'm Mark. Hi, Mark. Nice to meet you. Nice to meet you.
I'll just stay here.
So you used to be the ED? Yeah.
Humway-Warmuth. Humway-Warmuth. Where is Humway?
It had been changed, but it's Lebanese.
Oh, really?
We think it was like Shumway, or it was on a cantaloupe crate or something.
Okay.
Something to do with that.
That's really funny. Okay, I think we'll get started. So thank you for joining us. This is the session on home rule and LGBTQ plus legislation. I'm Valerie Blake. I'm one of the professors here at the law school, and I have the pleasure of moderating this panel. We have 3 distinguished panelists today. We're delighted they've come to speak to us. Each will have about 12 to 15 minutes for their remarks, and that should leave us a lot of time at the end for questions and answers. Our first speaker is Mark Dorosin, who's the managing attorney at the Lawyers Committee for Civil Rights Under Law, which is headquartered in Washington, D.C. Prior to this, Mark was the managing attorney of the UNC Center for Civil Rights for 9 years. Mark teaches political and civil rights and state and local government at UNC Law School, and he's also taught at Duke University Law School. Mark was previously a partner at the Chapel Hill civil rights law firm of McShirley, Dorosin, and Osment. He was elected to the Orange County Board of Commissioners in 2012, where he served as a chairman from 2016 to 2018, and he's a graduate of UNC Law. He will be speaking about North Carolina's HB2 bill, which has become widely known as the bathroom bill. Mark will explore how this legislation has forced the states to consider civil rights for historically marginalized groups, including LGBTQ people. Our next speaker will be Rosemary Humway-Warmuth, the city solicitor of Wheeling, West Virginia. Rosemary has served in that capacity for 22 years. Prior to that, she worked in the state attorney general's office. Rosemary has also previously served as the International Municipal Lawyers Association state chairperson for West Virginia, where she is a current board member. She is also the president of the West Virginia Municipal Attorneys Association. Rosemary teaches Introduction to Law, Forensic Evidence, and Trial Techniques at Bethany College in West Virginia. She attended Bethany College and Western Michigan Cooley Law School. Rosemary will be speaking about what municipalities in West Virginia have done and can do to institute LGBTQ reforms when there's no sign of change at the federal and state level. Our last speaker is Andrew Schneider. Andrew is the executive director of Fairness West Virginia, an organization that has led the effort to advocate for effective LGBTQ policy changes in the state. Prior to this, Andrew served for 7 years as the executive director of the ACLU of Connecticut, where he led successful state campaigns to win transgender civil rights, to abolish the death penalty, and to legalize medical marijuana, which is a lot of work. Before that, he was the executive director of the ACLU of West Virginia for 6 years. He holds a Bachelor of Arts degree in European history from Washington and Lee University. Andrew will be discussing how the expansion of LGBTQ equality goes to the very aims of the Home Rule program, in that it's meant for communities to decide for themselves how to make their homes a better place, and that can be one that's free from discrimination. So with that, I'll let Mark begin.
Great, thank you. Thank you for having me. It's great to be here, and I'm excited to get to talk about, to be on this panel with my colleagues here and talk about this topic. I'm gonna really run through the history of HB2, and hopefully we'll have a lot of good discussion during the question and answer on some of the impacts. But as many of you may know, in 2016, the city of Charlotte, North Carolina, amended its human relations ordinance, its anti-discrimination ordinance, to include sexual orientation, gender identity, and gender expression. That passage came after a year of grassroots advocacy by LGBTQ advocates in the city, an unsuccessful attempt to pass the bill, which I'll talk about a little more. And then finally, success. Less than a month later, the State General Assembly called a special session specifically to address what the leaders called the bathroom issues of Charlotte's new ordinance. And they announced the special session. 2 days later, the session was held. And in one day, they introduced, passed, and ratified HB2. It was introduced at 10 o'clock in the morning. The governor signed it at 10 o'clock that night. HB2, which has been mischaracterized as the bathroom bill, was actually a sweeping anti-civil rights measure that went far beyond the issue of public accommodations and bathrooms. The bill narrowly redefined sex to mean biological sex, the physical condition of being male or female, which is stated on a person's birth certificate. And not only addressed bathrooms, but addressed the ability to have any anti-discrimination laws based on sexual orientation or identity or expression. But HB2 went further than that. It also preempted a number of workers' rights provisions, including minimum wage laws, benefits, leaves, protections of minors in the workplace. The passage of the bill produced the expected national backlash, and a year later, the bill was quasi-repealed. What the lesson and what I really want to focus on is what the experience with HB2 teaches us about the issues we heard about in the last panel, kind of the general issues of preemption and the idea of having uniform policies across the state versus local control. But the North Carolina lesson really tells us more about how our political processes address, or in this case, fail to address, the expansion of civil rights for historically marginalized groups. It also taught us a lot about the continuing overtly discriminatory anti-LGBTQ language and policymaking, and also something else the last panel referred to, the issues of the manipulation of the legislative process, including through gerrymandering. So just to sort of quickly go through the history, while my talk is focused on North Carolina, the debate about LGBTQ rights that underlie HB2 really starts at the national level. There's a zoomed out perspective. So in April 2014, the United States Department of Education issues new guidance for Title IX implementation. It's a formal guidance document is issued, and it says, for the first time, expressly says that Title IX sex discrimination prohibition extends to claims of discrimination based on gender identity or failure to conform to stereotypical notions of masculinity or femininity. And OCR will accept such complaints for investigation. Similarly, this is again the guidance, the actual or perceived sexual orientation or gender identity of the parties does not change a school's obligation. So we had the federal government in 2014 for the first time taking a more expansive position on what the word sex means in one of the most seminal federal civil rights laws, Title IX. That is the beginning of the advocacy in Charlotte. So in the wake of that announcement, LGBTQ advocates in Charlotte start pushing for the idea of expanding Charlotte's human relations ordinance to include gender identity, gender expression, and sexual orientation. At the time, in 2014, Charlotte was one of only 3 of the 25 most populous cities in the country that did not have civil rights protections for LGBTQ individuals. And so there's a grassroots advocacy movement that begins. There's a lot of engagement with the city council, with the city attorney's office. And in 2015, they are successful in getting the city to agree to draft an ordinance and bring it forward. And in February 2015, that ordinance comes forward. By that point, there's already a growing conservative backlash to the proposal, and specifically, it comes primarily from conservative religious groups who are focused on the public accommodations aspect of the ordinance, which means you can't deny someone access based on any of these protected classes. And specifically, for the first time, we hear this question about transgender people being able to access restrooms based on their gender identity. In one of my favorite quotes in this whole story, the ordinance is coming up to Charlotte. They've gotten, thousands and thousands of emails, hundreds of people sign up to speak. One council member says, who is against making the changes, says that this change does not reflect the preference of the majority of our residents. And to which the mayor replies, with all respect, I'm glad we didn't put Brown versus Board of Ed to a vote. They have the first public hearing. There is this opposition. And what happens is the city decides to amend the proposed ordinance to exclude the gender identity and expression issues from the part related to public accommodation. So they actually propose a watered down version of the ordinance to eliminate the bathroom issue. And the ordinance fails. Opponents vote against it, but also two of the biggest proponents vote against it because they cannot accept the watered-down version. So the ordinance fails. And in the wake of that failure, what we see is what I would consider sort of the classic example of how democracy works. The proponents of that ordinance take their cues from the city council and turn their energies to the municipal elections, which are coming up in 8 months later. And they work assiduously to make this issue the core issue in the city elections in Charlotte. It's the topic of candidate forums. It really becomes, the municipal election becomes a referendum on the Human Relations Ordinance. And in November, the advocates in favor of expanding civil rights are successful. They elect 2 new city council members who are supportive of the ordinance, and a mayor who says in her victory speech that she's going to bring the ordinance back the first chance they get. Again, now back to the national context that's happening at the same time. During that campaign, the summer of 2015, Gavin Grimm files a lawsuit in Virginia. A transgender student files a lawsuit against the school district, which has passed a rule saying you have to use the bathroom that matches the gender on your birth certificate. Grimm and the ACLU file a lawsuit in Virginia, and immediately the governor of North Carolina tells the attorney general, the governor, Pat McCrory, is a Republican, the attorney general, Roy Cooper, is a Democrat. They will run against each other in the election in 2016. McCrory says, we should join this lawsuit on the side of the school district. And he sends a public letter to the attorney general and says, this must be stopped before our state schools are impacted. Cooper refuses to do that. McCrory files the brief in his own name to join the lawsuit. At the same time, now skipping a little bit ahead into January 2016, this issue further gets a higher national profile. The Republican National Committee adopts a resolution condemning government overreach regarding Title IX in public schools. And in that resolution that's adopted, the Republican National Committee specifically says state legislatures should enact laws that protect student privacy and limit the use of restrooms, locker rooms, and similar facilities to the sex that's identified on your birth certificate. Again, that's the national context. In February 2016, the Charlotte ordinance is back before the city council. The governor, McCrory, is sending emails to the Republicans on the city council telling them not to do this, that this ordinance, and this is really where you start to see, well, not start to see, but where the really homophobic, anti-LGBTQ rhetoric comes into place, which this idea that extending public accommodation protections to transgender persons puts people at risk of sexual predators. Right? That becomes conflated in the public image. McCrory says, this shift in policy creates a major public safety issue by putting citizens in possible danger from deviant actions by individuals taking advantage of improper policy. The City Council, despite those entreaties, passes the ordinance. And then, as I noted, less than a month later, the legislature calls a special session, and they pass HB 2. HB 2 does three things. And again, the impetus is this idea of bathrooms, and the idea that if you allow transgender people to use the bathroom of their choice, what you're doing is exposing women and children to dangers from sexual predators. That's equated in the minds of the opponents of this bill. So it has both a homophobic aspect to it and also a sexist aspect to it, because it's all these male legislators saying we've got to protect the women and children. HB 2 gets introduced. Part 1 says, deals with the bathrooms. It says, it redefines the definition of sex. Sex is what's on your birth certificate, and you have to use, if you go to a gender-specific restroom, you have to use the one that matches your birth certificate. That's part 1 of the bill. That would have done everything that the opponents seem to be most concerned about. But the bill goes much further. There's a second part of the bill that says there can be no local legislation changing any anti-discrimination laws to extend the definition of sex beyond biological sex, and also says that there can't be any local laws pertaining to the compensation of employees, wages, hours, benefits, leave, or the protection of minors in the workplace. And then there's a third provision where the legislature goes even further and eliminates the state anti-discrimination law that would have allowed workers to bring a lawsuit if they are discriminated against because it violates public policy. That was completely eliminated, not just for sexual orientation, but for anybody, for race, for religion, for ethnicity. I know I don't have too much more time, so I want to just speed through. The bill passes overwhelmingly. There's immediate reaction. The ACLU files a lawsuit. Several states pass travel bans prohibiting their workers to travel to North Carolina. PayPal, which had planned a $36 million center in Charlotte, cancels, which would have brought $36 million investment, 400 jobs to Charlotte, cancels that deal. Bruce Springsteen cancels a big concert that was coming. And it proceeds from there. The Federal Department of Justice sends a letter to the state saying, we believe this law is in violation of federal civil rights laws. Asks the governor what he's going to do about it. The state's response is to sue the Department of Justice for its interpretation of HB 2. The Department of Justice, in turn, countersues the state of North Carolina. There are more boycotts. The NBA All-Star Game pulls out. The NCAA pulls all of its postseason games out. There's a huge economic impact that is happening. Just to skip to the end, eventually there is a repeal that gets pushed through. It's a repeal that gets rid of HB 2, but as part of that repeal, it imposes a moratorium on any local government from passing any anti-discrimination laws until December 2020, December 1st, 2020. So we're still under that moratorium now. And then I'll save my analysis for when we get to the questions and answers.
Well, thank you, WVU School of Law, for having me and to be on this wonderful panel. The city of Wheeling is not unusual for a small municipality, smaller. We've lost some population, so we went from a Class 1 city to a Class 2 city, and in West Virginia, we're classified as through population. Class 1 is above 50,000, Class 2, 30,000, and 3 and 4 are smaller, and then, of course, villages and towns. But the city of Wheeling is one branch of local government within our state where we have always had a Human Rights Commission since in the mid of 1980s. So when the state adopted the Human Rights Commission laws at a state level. The city of Wheeling did form its own, which it has the ability to do that, formed its own municipal Human Rights Commission. It was fully staffed, and that's a big thing about these ordinances. It was fully staffed. It relies upon staff at the city of Wheeling, similar to our Board of Zoning Appeals, our land use, things of that nature. So there is secretarial staff, there's space, there's money provided by the municipality to fund the work of the commission. And the city of Wheeling, there was only one other city, Charleston, which is our capital, that actually took over the full analysis of complaints. The other commissions that existed in the state at a municipal level were really, I'd like to say, the touchy-feely, feel-good, PR type things. And primarily a lot of that is because of what I've just explained. They don't have full-time attorneys, and they don't have full-time staff, and they don't have any funding, et cetera. So that limits you in whatever your policy might be as to what you can actually get accomplished. So, but the city of Wheeling, similar to Charleston, we accepted complaints from day one on the basic characteristics that provided the complaints that we all know about at the federal level and the state level: sex, age, race, religion, handicap, et cetera. So those things that were recognized at the state level were recognized at the city level as well. And they were investigated at the city level. Again, a local analysis. And so throughout everything that the symposium stands for, Wheeling and many of our cities, we are also a home rule city, one of the first 4 pilot home rule cities since 2007 is, a strong local government is a strong state government. And the state legislators and at the state level really shouldn't be afraid of strong local government. Sometimes I fear that there is fear there. However, I digress. The city of Wheeling, though, we always had the authority, and we did investigate complaints. As the municipal attorney, you wear very many hats. So I would also advise that commission. Now, what was different in 2016 that changed the desire of the city of Wheeling to incorporate the transgender, the LGBTQ community within the ordinance? It's a very simple fact. There was an election in 2016. In 2016, our city government went from a median age before of about 63 years old to 29 and 30. That, to me, I think that was pivotal. Now, as you listened to my colleague before, this was also coming right upon the heels of what was happening with the bathroom bill. And so we got the same type of questions and concerns. Hey, this is Little Wheeling, what are you doing? We're not any big city, we don't really need this, and so we had a lot of opposition. However, the council that came in, there were 4 that kind of ran together, and really only one incumbent remained upon the council. So again, that was a pivotal time, and also the mindset. As the municipal attorney, what I always strive to do is, I always say, is I'm nothing but a tool for the governing body. What is it that you want to do? What is it that you want to do? And then I will provide you a path to do it, as long as it's not illegal, unethical, or immoral. But so in the past, and I know that some members of our panel are aware of this, but in the past, our Human Rights Commission, being that they were active since the 80s, they routinely sent a letter to City Council, almost annually, saying, please include these categories into our ordinance. And they were pretty much categorically denied. At least they would, and there was a basis for it. The council, again, they did not wish to expand the ordinance that was there prerogative and their discretion. And when asked, well, is there a basis for us other than just we don't want to? Well, the basis was the state has not recognized anything. The federal government has not come out and recognized these classifications. And a safe harbor, if that's what the council wants to do, would be to say, until the state or the federal legislatures act, then we feel uncertain and we don't want to be the first one to create the wheel in West Virginia, et cetera. So the change in the policy and the change in the mindset of this city council is what fueled the change in our ordinance. Now, the city of Charleston had done so before the city of Wheeling. They have a much more metropolitan population, a larger population, capital of the state, and they did change and expand their ordinance back, I believe it was like in 2012. So, 2007? And I know that in 2012 they had a big case, and I think Paul Ellis would probably talk about that best, and he's going to be on the Home Rule panel tomorrow, and I'll talk a little bit about that. But they were much ahead of the curve, and it was because they were, they recognized a need and a desire in their community at an earlier time, primarily. Now, they did defund their Human Rights Commission, and I think that was in 2012. They defunded some of it because they were, I mean, they are in the seat of government. The State Human Rights Commission is there. They can handle the cases just as easily as the city, et cetera. And so so anything that is recognized, the normal age, race, et cetera, those whole investigative powers were stripped out. And so they just immediately went to the state. But because the state didn't recognize the transgender and the LGBTQ community, that was kept in-house and was maintained within the legal department in Charleston. So really, the city of Wheeling is the only municipality that has that full powers and authorities to do a local review, investigation, a mediation, and even a follow-through to a potential probable cause. And so that's where we get to, we have and it's a wonderful law, it's a good law, and it does state in the purpose that the desire of the city of Wheeling to be an all-inclusive community, to be one that invites younger people, older people, visitors to feel comfortable in all ways, shape, and form. And so that was another big push. Our mayoral terms and council terms all are up again this year and every 4 years. And just 2 days ago at our State of the City, our mayor said, we are going to seek to continue to be a very inclusive community, to continue to try to get our young people to stay here and other people to move back and younger people to attract those populations. And they recognized that having an ordinance that at least gives some form of equality to our community was important in regard to how they wanted to govern. There are 13 cities within our state in West Virginia that have also adopted LGBTQ ordinances under the umbrella of a city human rights commission in the past 5 years. It's kind of been broad. Now, again, those other cities, and I think that there might be, you can address some of that, some of those other cities, the city of Wheeling was approached by the ACLU. We were very supportive. We did send our ordinance out to everybody with a cover letter saying that we supported this. Here's our ordinance. It's online. Please feel free, take whatever you can of it, copy it, use it. It's been kind of blessed by the powers that be, and is working well within our city. But these other cities, which are many of them are smaller, or many of them had never went down that road of having the investigative, adjudicatory type of authority that we have historically had. They pulled back a little bit on that. So they recognize these things, but then the question is well, what good is that? How does that help your citizenry? in Wheeling, and when I was speaking with Paul, because the city of Charleston, our ordinance looked much like theirs. You know, the thought that we have is that if you find that there's a violation of your local ordinance, a local law, it should be recognized in a cognizable claim in a civil rights action. There doesn't seem to be a preemption or a foreclosure of that. In fact, it seems to be a recognition that, you know, that if the federal law is to work in kind of in tandem if it does not preclude local legislation. So we feel that it is a door for persons if we find that there is probable cause to believe that there was discrimination based upon the LGBTQ community as defined, and we do define it as broadly as discussed earlier. Then it would be, it does provide a vehicle to perhaps get then to the other courts. In a human rights complaint, say it's very simple, just being discriminated against on a job issue because you're a female, the Human Rights Commission can make a finding of probable cause and then also issue a right to sue letter. So that right to sue letter then can be utilized in a civil action. So it's the same type of a parallel. It does not, if you file a human rights complaint, that does not foreclose you from another form of action. So we felt that this would be also a means that would give some semblance of, again, equality and fairness to that community in Wheeling. I will say that we had one council person, and they wanted the ordinance to be broader, to have more appeal to whatever base, which was absolutely fine. So we included the class of veterans. So it was not just, hey, this isn't just LGBTQ. We have a discrimination class right now for veterans. So that also went a long way because the veterans can be, can undergo discriminatory practices in regard to hiring and living situations and things like that. So we really modified our ordinance in a broader fashion. We did reach out. That was an important part. We had several work sessions with our Human Rights Commission, open to the public, not public speak and discourse for the work sessions. We probably had about 4 or 5 of those. They were large, they were publicized. We did invite stakeholders to also then participate. We moved our city council, which usually houses about half of this group, or a little less than on this side. Maybe it seats about, say, 50 to 75. We moved it to a local park, and there were approximately 250 people in attendance, and somewhere within 35 to 50 speaking, and some people speaking on behalf of groups. And we spent several hours that night with the information that was coming forward for consideration. And the ordinance did take into consideration maybe some modification in some language. The Catholic Church sent representatives to provide the city with their thoughts upon that. We had to speak to them to say, this ordinance is not trying to tell you what you need to do with your Catholic tenants. It has nothing to do with, how you run your church services, et cetera. We also had persons that stood up on several occasions and used the whole bathroom scenario. I have a little girl, oh my goodness, I can't have them in the bathroom with a person that is really a man, but in a woman's dress, this and that. And I spoke with a friend of mine who said, Rose, women have been going into men's bathrooms for a long time in bars and concerts when the lines are too long and things. And again, that thought that there was some form of a threat to the women and children, et cetera. So that was voiced. We also had people that signed up, and you have to let everybody speak. Public meeting makes a difference. So we had probably 10 people that were not in the city of Wheeling, were not even in the state of West Virginia. They were bussed in also. So it was quite a raucous evening. So we had those persons who did address, and we felt we made reasonable rules. So we did have sign-up sheets, so we could say, do you want to speak for? Do you want to speak against? Do you want to speak in a neutral? And are you in town or out of town? Because we were going to give preference to the people who this immediately affected, which was the municipality, at least to give them the courtesy of speaking first, if you will. So we didn't get any challenges on that, thankfully. But I thought it was fair. There are reasonable rules, and we did publicize that before the meeting. Anyway, it has been working well in the city of Wheeling. It was December of 2016 that we had 2 readings of the ordinance and another public presentation again before the vote. The vote was unanimous by the city council. And the one councilman spoke that he was persuaded because of the city including the veteran status. So I don't know if that was to appease a base or whatever. But we have since that time we have had 3 cases that have raised a transgender issue, and they have I can say they have all been resolved at this local level. Is it something that assists that community? We think that it does, and our commission does think that it helps, because also there's a greater awareness. Maybe there's a deterrent factor. The people sometimes even as attorneys who you counsel your clients, on different, say, foils or in harassment law or housing law, et cetera. That at least if you're within a community that like Wheeling, that's an area that you need to tell your clients about. That's an area that we try to educate the population also. Is we have enacted this law and it does apply to you. And so we've had it in a public accommodation setting. We've had one of the complaints that was based within an employment setting, and another one within another public accommodation setting. So and they were successful in the way that the complainant felt that they were heard, and that the remedy was acceptable. I mentioned Paul's case back, I think it was in 2012, because Paul's one of his first cases was a high-powered appointment was given to a woman and was extended to her, and then the next day, after the newspaper broke that this appointment was made, that it was found that she was of the LGBT community, and they revoked her offer. And at that time, there was nowhere else for her to go. It was accepted at that level. There was a finding of probable cause. It was ready to go to a federal case, and there was a significant settlement, my understanding is. So local legislation, is it helpful? It's at least helpful until the federal government or the state government acts. What is preferable is that the state government or the federal government would act. But until such time, it's a bridge, it's a tool, and it's something that has helped our community in Wheeling be more inclusive. And no county in the state of West Virginia has enacted anything. So 13 cities have stepped up and enacted something that recognizes this community and provides some semblance of equality for them.
Well, I can actually say a little bit about the frustration of the state government not acting. First of all, thank you, WVU Law School, for inviting me to participate on this panel. Normally, I would have to turn these kinds of speaking engagement, these panel discussion invitations down because it is right in the middle of the 60-day legislative session, where I am pretty much holed up lobbying on behalf of the LGBTQ community on our various civil rights bills, but also trying to beat back bills that could possibly take away or roll back our rights and freedoms. And unfortunately, I am sad to report that our major bill, the Fairness Act, the bill that would ban discrimination in employment, housing, and public spaces, was killed by the Republican leadership on day 2 of the session, the day before the legislation was actually introduced. And we kept hope alive that we might be able to bring it back with some certain compromises throughout the following weeks. But as it was crossover day yesterday, the last day that you can get a bill out of one chamber or the other before it dies, we were unsuccessful in persuading the powers that be that they should do this and make West Virginia one of the leaders in inclusiveness and non-discrimination. But we have hope, and one of the things that keeps us going is that we believe there is promise here in West Virginia to get this done, to make West Virginia the 22nd state to adopt an LGBTQ non-discrimination law. Now I say 22nd because we expect Virginia to do this shortly in the next couple of weeks, as soon as the governor signs the bill that has made its way through the state legislature. But the fact is, I really do believe that West Virginia has the capability, has the capacity to do this before half the country does it. And before I get started with my remarks, I want to pass along a sign-up sheet because we are only as strong as the people that are behind our efforts. And so if you would be kind enough to sign up on our list with all of your information, name, address, phone number, email, we can keep in touch with you during not only the legislative process of the 60-day session, but also during our various municipality campaigns, the ones that have been spoken about on this panel already. We may have a municipal non-discrimination campaign in your community in the coming months, so it's important that we can keep in touch with you. And I'm going to hand it to the nearest person, and please pass this along. So before I begin my prepared remarks, I want to talk about an issue that's come up on this panel that I feel like is important to address. That's what's been called the bathroom issue. It's what we call the transgender bathroom predator myth attack. And it came about in the most public way in Houston in 2015 when some very anti-gay pastors successfully got enough signatures to put their LGBTQ non-discrimination law on the ballot for repeal they have a referendum process there. And that was the first time that nationally we all became aware of this attack that conflated transgender civil rights with the bathrooms and with the demonization of that population, and the fact that somehow this would lead to the kinds of abuse of men dressing up as women to prey upon vulnerable women and girls in the public restrooms. And it's not, and it's an attack not unlike some of the attacks and segregations that have taken place in history, some of the things that are pretty horrible that we all can agree is pretty terrible. You know, the segregation of bathrooms for African Americans based on race, a segregation of public facilities for Jews in Nazi Germany. This is time and again the type of attack that is used in civil rights struggles to demonize a specific vulnerable, marginalized group of people. And so the opposition, I think, realized that by this point in time, most people knew someone or know someone who is LG or B, lesbian, gay, or bisexual. We have family members, we have neighbors, teachers, doctors, you name it, friends. Most of us know someone in that group of people. In fact, the Pew Center for Research did a poll a couple years ago and found out that 84% of Americans know someone who is gay, lesbian, or bisexual. But they also found that only about 15% of Americans know someone who's transgender. So the opposition obviously recognized that disparity and figured that they could more easily demonize the transgender population to not only try to divide our community, but also to to stop us in our tracks because we were making some headway in terms of civil rights progress in this country, and they were desperate to find something that would stall the progress. And in Houston, they succeeded. Their side spent somewhere in the neighborhood of $3 million. Nationally, our side spent the same amount of money, but we weren't prepared for the attack at that point. And Houstonians voted to repeal their law 60%, 60 to 40% of the vote. So naturally, when we were beginning one of our ordinance campaigns shortly thereafter in Lewisburg, the opposition believed that if this kind of attack can work in the 5th largest city in the country where there's a large LGBTQ population, surely it will gain traction in rural West Virginia. So signs go up all over Lewisburg saying, vote no against Ordinance 254 to keep men out of women's restrooms. And it's not long after that, we have a first reading. The ordinance advances out of first reading to the final vote. But before the final vote takes place, I get a call from the mayor. And the mayor is very concerned. He is worried that his town has been turned upside, his city has been turned upside down by this ordinance campaign, and wonders if maybe we should delay the vote by 6 months, because that would give us a chance to talk to some of those on the opposition, those who've been persuaded that this could lead to problems in the bathrooms, and maybe we could soften their hearts and bring them around and have public forums to bring everyone together. And what I said to the mayor is, with all due respect, I don't think you're going to soften those hearts by delaying that vote, by subjecting it to a different timeline than any other ordinance you've ever taken up. I think, in fact, if you do that, they will smell blood in the water. You will undermine your authority for the remainder of your term. And I think that would be a huge mistake. And we must have spoken for like an hour and a half, and I wasn't sure if I had persuaded him. And that actually happened to coincide with the time when I was at the legislature lobbying against this awful bill that we call the License to Discriminate bill, otherwise known as the Religious Freedom Restoration Act, that would have allowed people to discriminate in the name of religion. And it looked like we were going to lose that vote by as much as 65 to 35 at that point. In fact, we ultimately lost it by 72 votes, but we then defeated in the Senate. I won't get into that story because it's long. But it was a tough time for me, professionally, because things didn't look like they were going too well. And I just remember having a colleague of mine who was doing some video work for Fairness, our organization, and we needed to get the Wi-Fi password from the Office of Technology in the basement of the Capitol. And we went down there. I'm dressed in my suit. She has her camera on her shoulder, and the director of technology looks at two of us and says, "Are you the press?" But because of our state of mind, what we had heard was, "Are you depressed?" Oh my God, are we wearing our emotions on our sleeves? That's really the way it felt at that point. But fortunately, Lewisburg did not capitulate to the tension and the controversy swirling around this ordinance. And they ended up holding the city council meeting, the final vote, essentially according to the same timetable. But because of the fear generated over these attacks and the interest that was generated over this ordinance, they decided to move their city council meeting from City Hall, which could accommodate approximately about 70 people, to the osteopathic school, which could accommodate approximately about 500 people in their auditorium. And because of the worry about potential violence, they had a full detail of state police present. In fact, as you pulled into the parking lot of the school, a state trooper would ask you to roll down your window and ask you which side you were on. And so given what answer you gave them, you were sent to a different side of the parking lot than the other side. And then you were expected to enter through a different entrance of the school. And then finally, you were seated in a different section of the auditorium. They kept us apart because we were worried, very worried, that we wouldn't play nice with each other. So there were about 45 people on each side who spoke for and against the ordinance. And of course, I believe my recollection is that everyone in the opposition spoke against the ordinance using the bathrooms as their reason, as their rationale. So at the end, the meeting started at 7 p.m. that night. By the time the public comment period was concluded, it was 12:30 in the morning. And finally, the city council members had a chance to weigh in. The first city council member to weigh in was a council member by the name of Mark Etten. He turns to the city attorney and says, "Sir, are there currently any laws regulating the use of public restrooms?" The city attorney responds, "No, sir, they're not." And he asks, "So that means a transgender woman can use the women's restroom, there's no law barring her from doing so?" "That's correct, that there's no law barring her from doing so." "So then if we as a city council adopt this ordinance tonight, will that change anything regarding the bathrooms?" "No, sir, it will not." Thank you, no further questions." And then he turns to the city police chief. "Chief, if our city council approves this ordinance this evening, will you enforce the laws against sexual assault any less vigorously than you've done so in the past?" And the city attorney responds, "No, sir, we'll continue to enforce the laws against sexual assault just as forcefully as we've done previously." The city council thanks him as well. And then that takes the wind out of their sails. And then they end up voting, and they end up approving that ordinance unanimously in Lewisburg, population 3,500. And that sets the example for a record number of municipalities that year. This is 2016. After, not even 2 weeks later, the city of Martinsburg unanimously approves an LGBTQ non-discrimination law. Then comes Shepherdstown, then comes Charlestown, and then at the end of the year, Wheeling. Unanimously Wheeling, by the way. And I thought it was great that so many communities were coming on board, but what I didn't realize is after Wheeling adopted their ordinance, I get a call from a national organization that's praising West Virginia because West Virginia apparently adopted more municipal LGBTQ non-discrimination laws in 2016 than any other state in the country. Yeah. So that is what gives me hope, that we have the potential here of doing this, and of doing this on the state level before half the country does it. That's why I'm committed to this work, even if it's frustrating that we have our bumps in the road, and there will be bumps because these things are never easy. They're never wrapped up in a gift and handed to you on a platter. You have to work for them. So please sign up on that list so that we can call on you when we need you for the fight that will actually make a difference. Now I'll return to my prepared remarks. So in just a little over a decade, 13 municipalities have adopted local fairness laws. These laws help ensure that no person is fired, evicted, or denied service in public spaces because of who they are or who they love. Shortly after the legislature launched the Home Rule pilot program in 2007, the city of Charleston became the first municipality to adopt an ordinance banning discrimination based on sexual orientation, gender identity, and a dozen more municipalities have followed. But Charleston and other cities don't need home rule to enact these local fairness laws. The state's Human Rights Act only provides for a limited number of protected classes, but it explicitly states that the law may not supersede any local non-discrimination laws or municipal charters. In 2019, as you know, the legislature made the home rule program permanent. When it did, a few lawmakers attempted to prevent the adoption of the bill without including an anti-LGBTQ provision. They wanted to allow a small minority of voters, 30%, to recall an ordinance through a referendum process specifically designed to target the local fairness laws. Now, some people might say that sounds all right in theory, but it would have had the effect of subjecting civil rights protections of a minority group to the whims of a majority. It would have had a chilling effect on future municipalities from even considering adopting a local fairness law out of the fear of facing an expensive and divisive referendum. To show you how ridiculous that would be, let's look at the town of Athens, the town in the heart of Delegate Porterfield's district, I might add.
that became the 13th municipality to adopt a local fairness law just a few weeks ago. If these referendum provisions were adopted at the state level, as few as 23 people could have forced the town to hold a special election to decide whether LGBTQ discrimination should remain illegal. And we know that voter turnout is lower in these kinds of off-year municipal elections. Local fairness laws aren't the only way that municipalities are stepping up for LGBTQ people. Across the country, dozens of cities have taken steps to ban the dangerous and discredited practice of conversion therapy. This is a mostly underground practice that attempts to change someone's sexual orientation or gender identity. And it's mostly underground because every major medical association has condemned it. It can be devastating for a child to be subjected to this practice. It can lead to higher rates of depression, self-harm, and even suicide. Our bill to ban conversion therapy across West Virginia would allow the state to revoke a medical professional's license for using this practice. Considering how serious this practice is, some states and cities have taken it upon themselves to ban conversion therapy in minors. Courts have long upheld that these types of bans are constitutional, and we've introduced a bill every year to bring a ban to West Virginia. We've yet to see any movement at the legislature. And I think it's worth considering if municipalities can do more to help this fight. In 2019 alone, 19 cities enacted conversion therapy bans. To give you some background, it's more challenging for cities to ban conversion therapy than it is for states. In October of last year, a U.S. district judge in Florida actually struck down Tampa Bay's conversion therapy ban. It wasn't struck down because the ban itself was unconstitutional, but it was struck down because the city didn't have the home rule authority to enact the ban. The bad news is West Virginia's municipal home rule program brings some significant barriers to any cities hoping to ban conversion therapy. In the law, it specifically prevents municipalities from enacting laws contrary to, quote, laws governing professional licensing or certification, including the administration and oversight of those laws, end quote. With this provision, it seems that municipalities might not be able to adopt our conversion therapy ban directly into a local ordinance. There's some gray area here, though. There might be ways to effectively ban conversion therapy without involving a practitioner's license. Perhaps Charleston or Morgantown could enact an ordinance to revoke the business license of a clinic that uses this therapy. We'd love to see municipalities step up and use some creativity to help end this terrible practice. The truth is, LGBTQ issues are at the heart of what the Home Rule program is all about. The Home Rule program is founded on an idea that communities should be allowed to decide for themselves how to make their homes a better place. Nothing makes a community stronger than making sure that everyone is able to live free from discrimination. The Home Rule program is meant to allow municipalities to find ways to make their communities operate more efficiently and attract new businesses. Nothing helps attract new businesses than ensuring that the best and brightest talent will be protected from discrimination, no matter who they are or who they love. Thank you.
You know, playing on that, because Andrew's been down at the legislature, every year the legislature, except I haven't had many this time, but the legislature has attacked the home rule to attempt to, when we attempt to amend it, home rule was scheduled to sunset. So we had to argue about the sunsetting. Then home rule was expanded to include smaller communities. And every time we opened that up, there were other legislators that wanted to put more stumbling blocks about things that we could not do into it. Some were gun provisions in regard to in public places that banned local legislation, and we were threatened pretty much in regard that we do have a strong legislative West Virginia Municipal League that does lobby for cities, but there were comments like, hey, you're one of those home rule cities, right? Oh, you're one of those cities that have those LGBTQ things. That type of discussion and that type of talk was thrown at our members of our governing body that were at the legislation, that they were, it seemed like they were attempting to put in some laws, not only that would say anybody who joins into the home rule or wants to amend, you have to submit an amendment to your home rule plan that might, that basically would preempt any inclusion of any LGBTQ or any type of an ordinance at a local level. And there was even discussion that any home rule city that had adopted it, that they were going to attempt to retroactively say that it cannot be, it must be disbanded. So the attacks had continued through last year.
Yeah. And we see these attacks every year. There was a preemption bill introduced this year. Fortunately, I think our legislature has gotten a little better every year, because back in 2015, this type of preemption bill, which we called it the Abolishing Local Liberty Act, we always try to come up with clever names to demonize their bills too, and basically that bill made it into committee and it was voted out of committee. It was voted out of committee largely along party lines, and we almost didn't know about it. It was one of those things that was put on an agenda. In fact, it happened, that bill was introduced the day or 2 days after we helped the town of Thurman to adopt a non-discrimination law. By the way, Thurman, in case you're not familiar, is now the smallest town in America with an LGBTQ non-discrimination law, population 5, and all 5 of them voted for it. It was unanimous. But it was actually such a PR win, as well as just a symbolic win for Thurman, that the opposition hated it. It really got under their skin. So a couple days later, a bill that would preempt that, it was called the Intrastate Commerce Act. They try to come up with clever names. And this bill would not only prohibit future municipalities from adopting these laws, but it would have essentially abolished at the time we had only 7 municipalities with these laws. It would have abolished those laws in those 7 municipalities, including Thurman. And so it was just very mean-spirited. And a couple days after the bill was introduced, because it was like the last day a bill could be introduced in the House, it came up on the agenda. But the chair of the House Government Org Committee put it on the agenda at like 10 o'clock at night after all the lobbyists had gone home, hoping that no one would hear about it, no one would know about it, and it was scheduled for a vote the next morning at 9 in the morning. Fortunately, there are lots of people who are supportive of our efforts in the Capitol, and there are people, who are working, for these legislators, and we got wind of it, and we were able to basically get a letter on our Fairness West Virginia stationery to request a public hearing. And if you can request a public hearing, that delays the bill from moving to the floor by 2 days, because they have to give the public 2 days notice to attend the public hearing, the ability to attend the public hearing. And that was precious time for us, because in those 2 days, we were able to generate over 300 phone calls to House members urging them to defeat that bill. And the volume of calls and emails that were generated basically made the Republicans skittish of moving forward on this legislation. And it was basically the day of the public hearing, we heard that the bill was dead. So since then, we've not seen really any threats or problems regarding these types of preemption bills being going anywhere or having any serious threat. They are introduced every year. We had one introduced this year, but it didn't go anywhere, fortunately.
Okay, so let's open it up to the audience for questions. But first, let's get a round of applause for this excellent panel. Okay, looks like we have a microphone in the back.
Any questions?
I really want to thank the panel. We're all so fortunate to hear from 3 practicing attorneys really doing the work right now. I'm originally coming from North Carolina, and it reminded me, I hadn't thought about it in a little while, the few years leading up to the bathroom bill had some other history in that state, and I'll be interested to hear from our West Virginia colleagues if you've had any similar issues. But I was supervising a whole handful of 1L Duke students on a summer project, sent them all into a court observation program. One student reported to me was very disturbed because a Durham County judge had refused to let a young African-American man who was Muslim testify until he took off his head covering. He said, no hats in court. And so the witness never testified, and he just left the court. And so the Duke student says to me, this is just so wrong. And I said, fine. I was sort of new to the state of North Carolina at the time. I'm from California. I said, let me check out our code of ethics. I said, I can't find an anti-discrimination provision. So let me call the North Carolina Supreme Court. So I did. And I spoke to the clerk, and I said, I don't have a provision to show this student should he choose to file some kind of complaint against the judge. And clearly it's race and religion. And the clerk says, hang on, I'll call you back. So he talks to the court, calls me back, and has the integrity to tell me what I was supposed to know, which was there are federal laws in place, it's good enough. We don't need that. We've looked at this before. We don't need that in North Carolina. So the student was very discouraged and chose not to file anything because it would have been too much of a battle to try to make this up somehow. So the importance of having this express, having something that an attorney could attach and hang on to that is actionable is so important. Jump ahead just a few years. By this time, I'm very active in the Association of Women Attorneys at the time that they and the Black Lawyers Association and a number of attorney groups are trying to get an anti-discrimination provision into our code of ethics for attorneys, at which point the biggest pushback was that it included gender identity and sexual orientation. They would not pass a bill unless it was watered down, not a bill, but a provision. And I remember thinking at the time, please everybody hold tight together. Do not back off, right, until we have this all together. And what struck me the most was, I started to collect them, were letters from attorneys to the state bar that were so vicious and homophobic, opposing these provisions in a self-governing profession. And it just struck me how important it is that practicing attorneys who have the courage to stand up, for those who have even more courage to live the life of what they're facing with all of this, how key that is in all of this. So as we talk about home rule and local authority, I think this panel is an excellent reminder of how important the legal profession is, how important it is that law schools are in teaching people how to use their voice effectively, because at the local level, it's your local attorneys who are really standing up and fighting the fight. So I just really want to appreciate what you said, and I'm curious, I kind of know what happened in North Carolina, but I'm curious in West Virginia, as a self-governing profession, how discrimination within attorneys and judges and the rest, how that's handled here, if you think it's handled well. Because if those folks don't self-govern well, how are they going to advocate for everybody else? Sorry that was so long.
Well, first, I want to debunk another myth. I'm not an attorney. I mean, my dad always
can be
wanted
honorary.
My dad always wanted me either an attorney, a doctor, or a rabbi, and I disappointed him on all three. but so I'll defer to you.
Well, there is most lawyers, and it is a more of a self-governing. But I find that in the Ohio County Bar and in areas where, in the Charleston Bar and things, that there are members of the LGBTQ community that are attorneys that do live the life, as you say. I think that being that we have 13 cities that have a local ordinance, there are attorneys that have represented persons who have complaints. And so I think that there isn't anything in regard to bar rules, et cetera, that I'm aware of. However, I think there's an openness, if you will, to that really doesn't have a place within our practice. And many of the judges, I think, are of that same bent. Now, I will tell you that it is different in different parts of the state. If you look at this, you need to look at the complexion again, a map of the persons who have adopted it. There are other pockets. There are, like, Parkersburg is a Class 2 city. It's a large city, and so we're working on them. But you know, it is different. It may be different in regard to the makeup of the political party within those areas. But we do recognize, like you said, I was talking with a gentleman and his partner after our Human Rights Commission meeting last week, and he said it made all the difference in the world for them to stay in Wheeling. And he said, you know, every day in my life, in our lives together, and they're married, and he said, and I'm always worried that my marriage is going to get somehow legislatively annulled. And he said, but you know, life is hard enough for all of us and in this world. And it's very hard sometimes when you're wondering that your freedoms and things are going to be taken away by a governing power or a law, et cetera. And he said, you know, that's a different layer of anxiousness that many people do not face on a day-to-day basis. So it's good to have heard that and to have recognized that locally, at least, they feel they have protections.
But you make a good point. I mean, what we're really talking about here, is institutionalized discrimination against the LGBT community. And so, and the legal system is an institution infected by that same institutionalized discrimination. And what's so compelling about these local ordinances, and I'm jealous to hear about all the success in West Virginia, given that it's been banned. You know, the local governments don't have this power in North Carolina. I mean, what's compelling is that these ordinances, these local legislation, you know, unlike historical civil rights victories that have been court decisions, you know, what this legislation brings is an institutional impact that a favorable court ruling does not, right? These ordinances represent really the popular and public endorsement of the inclusion, the full inclusion of the LGBT community in the same benefits and protections that other residents have. And it really goes, I mean, the history of maintaining, you know, that discrimination has been about exclusion, about keeping those groups out. And so these ordinances are so important because they get to that institutionalized piece of the discrimination. And the anti-trans rhetoric about, you know, attacks and deviation, I mean, all that rhetoric is grounded in maintaining the idea that these are folks who should be kept out of the benefits that the rest of us have, right? The implication is that these are dangerous people that don't deserve the same rights and protections as everyone else. And that's why that rhetoric was so, you know, was successful in Houston. It was successful in North Carolina. It really was. They were able to drive the debate using that overtly discriminatory rhetoric. The other interesting piece in North Carolina, just to sneak this in, even though it's leaping from your question, is in North Carolina, the other piece of the rhetoric that was so fascinating was in the legislative debates about HB2, in the legislative debate about passing it, one of the big attacks was that what happened in Charlotte was undemocratic, right? That the city council was somehow a less democratic place than the General Assembly, right? The idea was that, you know, that a few radicals who were getting money from out of state, you know, and people from being bussed in, that they pushed through this agenda. And they didn't have the kind of careful, deliberative process we have in the state legislature, where we have a committee system and we have two houses and everything has to happen. And you know, the whole idea of undermining this was the idea that that somehow what happened in Charlotte was undemocratic, even though they lost the first time, they worked to elect new officials who were supportive of the position and won the second time, and over the course of a year, that was somehow less democratic than ramrodding the HB2 through in one day with almost no debate, with a veto-proof majority. And so you have these two pieces come together in North Carolina that helps justify this preemption. That really what it serves to do is continue to marginalize excluded groups.
And I just want to say one thing. Rosemary, you brought up the distinction between communities in West Virginia that have human rights commissions where you have a process, the city has funds to actually pursue some of these cases. In most of the communities in West Virginia that have these fairness laws, they're not as fortunate as Wheeling, like the town of Athens that we just worked with a couple of weeks ago to adopt theirs. Those types of towns and the smaller cities basically enact these laws that don't require any financial burden for the city because they simply provide a civil cause of action for victims of discrimination to find a lawyer and bring their case to court. And that's the beauty of it, so that there's no burden for these towns and communities to do the right thing and become inclusive communities. They can do it simply by just wanting to do it.
So it looks like we have time for just one more very quick question, and then we'll wrap, and hopefully our panelists will be able to stay.
Thank you all for coming. We really, really appreciate you being here today. I am just wondering, so you mentioned Parkersburg, West Virginia as a city that is not quite on board. I am actually from Parkersburg. I'm a second-year law student here, and I was wondering if you had any advice for any of us law students, future lawyers, to be able to kind of push, enact change, whether through volunteer work, whether through any kind of writing of any sorts that could kind of push through and make changes in the cities in West Virginia where you would think we would be further ahead on these things, but we aren't yet. I mean, I think you all are quite aware it's really mainly just one person that has kind of monopolized the scene at city council meetings there, and for some reason his rhetoric really resounds in the community, and I'm not sure why. But if you have any advice on how law students or aspiring lawyers or lawyers now, what we can do in our home communities to enact change in those types of situations.
Well, I simply think that I know Joe Santer is the city attorney down there, and he's been there for decades too. He's very knowledgeable, very fair individual. And Parkersburg, you guys it's a very large council, isn't it? Sometimes that's like herding cats, if you will. So that could be difficult. We have 6 and one mayor, 7. So that's a large number of people. And all I can say is, again, it may just center around 4-letter word like vote. It's the political process and things of that nature.
Yeah, I would just echo that there is a very active community there that is trying to change the law. They are actually been involved in recruiting candidates for the city council election that's coming up. I would say the best thing to do is help those candidates who are running, the ones that are pro-LGBT, making sure that those candidates who are running for city council have to answer to this particular issue, so you know where they stand. Often these issues don't get talked about on the local level, but getting together with others to bring this up, to become part of the public conversation, I think is enormously helpful at this point when you can actually make change through the electoral process.
Are there any announcements we should make before everyone leaves?
Thank you guys so much for sharing your experience with us, and Professor Blake for moderating. And thank you to all of our panelists and speakers today for traveling and sharing your expertise with us. It's been really informational for me personally, and on behalf of the Law Review, we would just like to say thank you to all of you who have traveled here today on this snowy February day. And we hope that you will join us again tomorrow. We will begin at 8 a.m. for breakfast. Welcome remarks will begin at 8:45. And our first panel tomorrow will be criminal justice reform beginning at 9 a.m. in this room. Thank you. If you have any questions, catch a member of the law review and we will be able to fill you in. Thank you.
Thank you.